Thank you all for joining. We're live across social media platforms. Today, we're going to be discussing a very important topic, as always. USCIS has released a new policy memorandum that we're going to be discussing on the types of cases they're going to be referring to immigration court. So we're here to discuss the new policy. Please drop me an emoji if you can hear me. If you can find the US flag, feel free to drop that, or the flag of the country where you're connecting from. Feel free to drop it in the chat box or the comment section so we can get started. Don't forget to share this live feed. Now, immigration has become like a very dangerous drug. If you have immigration problems, it's usually not advisable to discuss it with people because you never know, right? So even if your neighbor needs immigration help, chances are they may not tell you that they need immigration help. So share the live feed, share the video with your family and friends. You don't know who could benefit from the information we're going to be sharing. Okay, so share the live feed. Share the live feed and let's get started. I'm going to be sharing my screen with the people on Facebook, LinkedIn, and YouTube. You guys drop your comments. I can see Instagram can hear me really well. I see them dropping the US flag and the flag of the country they're connecting from. I don't see it with the other platforms. If TikTok and YouTube, Facebook, if you guys can hear me, please drop something in the chat box or the comment section. I'm sorry. Let me shift this a little bit so I can put this here. The discussion today is or concerns USCIS NTA policy issuance update. All right, there you go. Okay. Facebook, let me see that you guys can see me and hear me really well. TikTok, drop an emoji, the US flag or the flag of the country you're connecting from, and we can just get started as we wait for a couple more people to troop in. Okay, so let me share my screen now. Let's see here. And then we can get started because we don't have too much time. All right, let me go back. Looks like I was, it scrolled all the way down to, StreamYard. Okay, there you go. Now let me see where we can get started from. Okay, excellent. So as you guys can see, if you're on YouTube, you're on Facebook, you are on LinkedIn, you can see my screen. You're all welcome to this live feed. My name is Ikuya Attorney at AK Puku Law. We're a U.S. immigration law firm. Today, we're going to be discussing the latest policy memorandum that was issued by USCIS, United States Citizenship and Immigration Services. And the subject of the policy memorandum is issuance of notices to appear, NTAs, in cases involving inadmissible and deportable aliens. So you guys already know when you hear them say aliens, it's referring to immigrants, non-citizens, immigrants who are not US citizens. So long as you're an immigrant, you're a green card holder or what we call a lawful permanent resident, you're an immigrant, you are on a visitor's visa or a student visa or some type of temporary visa. So long as you are not a US citizen, then you are an alien. Okay, so this is for all persons or people who are not US citizens and who find themselves in the United States. At what point will USCIS issue something called a notice to appear? Okay, notice to appear, we're going to look at what that is. A notice to appear is a form called a Form I-862, and it's a charging document. That's the document you will receive if you are being summoned to immigration court. It's a very serious document, and it's a document that when you get or when you receive, you haven't received good news. Okay, primarily because number one, it means that you have been put in removal proceedings. You've been put in removal proceedings, and you're going to be meeting an immigration judge, and you're going to have your case prosecuted in immigration court. And so the government will be, on the other side. It's a very adversarial process. Adversarial means combative, right? So it's like, okay, it's a very serious process where you are being accused of certain things and you have to defend yourself. So that's what we mean by it's an adversarial process. So number one, it's a big deal because you're in immigration court. And number two, the other reason why it's not fun to receive a notice to appear is because there's just so much backlog in immigration courts that when you end up in immigration court, you could likely spend 4 years, 5 years, 6 years, 7 years, 8 years, even 10 years in immigration courts. And until your case is over, you cannot really sleep well, because at the end of an immigration court process, you could either be ordered deported or removed from the US, or your case could be dismissed from court, or you could get a green card from the process. So it doesn't always end badly, but the process is very stressful and financially draining. It takes a lot of your money and it's quite stressful. It could go badly and it could go well, depending on how things work. So the charging document, the Form I-862 notice to appear, is a document that you must fight hard to make sure that as much as is within your power, you do not get summoned to immigration court. That's something it's a no-no. Just make sure whatever you're doing, don't receive a notice to appear. And there are ways you can avoid receiving a notice to appear. We're going to be looking at what the new policy memo is. And the new policy memo actually lists or discusses 8 main areas or points. We're not going to be able to look at all the 8 main areas in this live video, but I'm going to go over the 8 main areas, and then we're going to zero in on a few of the crucial areas where you have to know, where you have to be aware that you could be summoned to court or called to come to immigration court if you do certain things. And then you see how you can avoid getting there. Okay, so the first part of the memo talks about NTA issuance as required by statute or regulations, what's called regulatory NTAs. Okay, so apart from the fact that, for example, USCIS could, let me take this thing off. Let's go back to comments. Okay, USCIS, apart from the fact that USCIS could, as a matter of discretion, or even as a matter of policy, issue you with an NTA in certain situations, there are some situations where the law requires an issuance of NTA, meaning the law will say that, okay, if you find somebody in this situation, send them to immigration court. There's no discretion here. Just refer those people to immigration court. This is the regulatory NTAs. I'm sorry, that's the first one. First area. Second area, where the policy memorandum discusses, is national security cases. Third area is criminal cases. People who are, who have criminal arrests, criminal convictions. Those type of people are going to be sent to immigration court as well. Fourth area of discussion has to do with people who have fraud and misrepresentation in their immigration cases. Those kinds of people also, there's a policy for sending them to court. Then we have temporary protected status, in what cases or situations you will be sent when you have a temporary protected status, or TPS. Then the sixth area we'll look at is the aliens or non-citizens who are not lawfully present in the US, or they're subject to other grounds of removability. So you know, for example, if you apply for a green card and your case is denied and you are out of status, number 6 discusses the fact that USCIS has to issue you with an NTA or a charging document and send you to immigration court. Number 7, special circumstances involving when notice to appear will be issued. Again, they mention denied cases and, you know, beneficiaries of some employment-based petitions. Then number 8 is prosecutorial discretion, how USCIS will exercise that discretion in deciding to issue an NTA or sending you to court or not. Okay, so let's get started with the first area of discussion. Let me see here. Okay. So with the first area, we're going to be looking at regulatory NTAs. Let me scroll down what's going on here. Okay, well, let's go back again to what an NTA is. It's a charging document that, among other things, it will instruct a non-citizen to appear before an immigration judge. That's what an NTA is. It will instruct you to appear before an immigration judge, and it will specify, or it will detail, the nature of removal proceedings against you, and it will also cite the legal authority for the proceedings. Number 1, it will cite the factual allegations against you, how you enter the United States, what your status is, you know, the factual allegations that support the fact that you should be removed or deported, and then the charges that are against you, that are being brought against you. USCIS does have authority under immigration laws to issue notices to appear, and, you know, thereafter, notice to appear is filed with immigration court to start removal proceedings under Section 240 of the Immigration and Nationality Act. Okay, you guys are going to have a chance to ask your questions, so don't worry, we'll be getting to questions session soon. Okay, so under regulatory NTAs, we'll not look at everything, but we'll just pick a couple of examples. One of the most common ways to get yourself in immigration court, number 1, if you have your conditional permanent residence status terminated. Okay, so there are 2 types of green card holders in the United States. We have the conditional permanent residents, and then we have the 10-year green card holders. The conditional permanent residents are people who have 2-year green cards. The other types have 10-year green cards. If you have a conditional permanent resident card, usually means for those who got their green cards through marriage, their marriage was less than 2 years at the time their green cards got approved. 90 days before your green card expires, if you're trying to file a joint petition to remove the conditions from your green card, then you need to do so with your spouse 90 days before your green card expires. Now, this law was introduced in I believe in the early 1990s, where they wanted to put a roadblock, or they wanted to prevent people from entering into fraud marriages. And so what the government said they would do was that if you applied for a green card based on a marriage, then they were going to give you a conditional green card, where they would give you, well, it's a green card, it can do everything a 10-year green card can do, just that it's only valid for 2 years versus 10 years. So that 90 days before that 2-year green card expires, you file again to immigration and tell them, oh, 2 years ago, we applied and said we were married. Here's how the marriage is going. Here's what the relationship is looking like. Here's how we've evolved. See, it was a true marriage. It was not a transactional marriage. And now what happens is that if you apply for the removal of conditions and for some reason it's denied, then you're going to end up in immigration court. You know, there's some conditional permanent resident statuses that are obtained through the investor visa, through the EB-5. We won't focus on that now. So if your conditional permanent resident status is terminated, you'll find yourself in immigration court. So you got to make sure that you remove the conditions on your green card. Some people make a mistake here. They go file the I-90 instead of the 751, 2 separate processes. You can only do the I-90 if you have a 10-year green card and you're renewing, or replacing a lost green card. If you have a conditional permanent resident status, you don't renew the green card, you remove the conditions, right? So you want to make sure you are doing the right thing. Even if your marriage has broken down and your spouse says, oh, I'm not going to help you remove the conditions, there are ways you can file something called a waiver of that joint requirement. There are exceptions to filing the joint petition. So you either file with your spouse to petition the government to remove the conditions, or you can file the petition by yourself without the help of your spouse, so long as the marriage was a genuine one, you entered into it, there was no exchange, quid pro quo, like, okay, I'm giving you $30,000 and then we say we're married and then I get a green card through that. The marriage cannot be based on a transaction. It has to be based on the fact that you intend to establish your life together. So therefore, even if the marriage ends in abuse or divorce or death, without your spouse, you're still able to remove the conditions. Please don't wait until you end up in immigration court before you try to remove the conditions. Yesterday, I had an in-person consultation with a potential client, and very interesting. His green card expired about 10 years ago, and he did not know. Can you guys believe it? He kept his green card in a safe place and never bothered to check when the date of expiration was. He had been working at the same place for several years. They knew where he worked. The work people knew his status and knew that, oh yeah, he's a green card holder, and also never bothered to check whether he had valid status. And his green card expired 10 years ago, and he's now getting to it. And he even came not to even address his own issue. He was trying to file for somebody else. I'm like, let's focus on you. We have to sort this out immediately. You cannot be walking around with an expired green card, expired status. Again, remember that you are and continue to be a lawful permanent resident status of the United States until that status is, taken away in court, or you abandon that status. Okay, so the green card expiring doesn't mean your status has expired. The green card is only evidence of your resident status. The green card is not what gives you status. You already have status by operation of law. And so even if your green card expires, you continue to be a green card holder of the United States. So expired green card, lost green card does not mean you are not a lawful permanent resident. You can lose your permanent resident status by operation of law and in certain specific situations that we'll discuss later. Okay, so make sure that if you do have a 2-year green card, you're keeping an eye on the date of the expiration. You cannot, especially not at this time, you cannot afford to not be focused on your immigration status and be intentional about it, about renewing, about proactively doing what you need to do to ensure that you're maintaining status at all times. Okay, so just ensure that you file removal of conditions when you need to file it. Let's go on to the next. Let's see. Well, national security cases. Not that many people are a threat to national security, but if you are engaged in or you are suspected of terrorist activities, then you will be prioritized. Your case will be sent to immigration courts. Once USCIS realizes that you're a threat to national security, you'll be referred to immigration court. So that's the second one. Then under criminal cases, DHS prioritizes the apprehension, or they prioritize arresting and removing non-citizens or immigrants who pose a threat to public safety. So if you have filed a case with USCIS, for example, you're applying for a green card and you have arrests or convictions, or you have you've raped somebody, you've beat up your wife, or you've hurt someone, or you've stolen something, you have a history that involves criminal conduct or interactions with the police, that is a problem, and you're going to be referred to immigration court. Your case will be referred to immigration court. So it says USCIS refers cases involving criminal conduct, arrests, or convictions to ICE for enforcement determinations, including, so they're going to refer your case to ICE for enforcement action determination, whether you should be removed from the United States, whether they're going to investigate you further, and NTA determinations pursuant to the applicable agreement with ICE regarding referrals to ICE. So ICE is going to, USCIS will in some cases refer you to ICE to determine, should this person be removed? Should there be an enforcement action taken against the person? Okay, subject to the referral to ICE process, USCIS will issue a notice to appear, an immigration court summons against removable aliens or non-citizens if they have been arrested, charged with, or convicted of a criminal offense if the benefit request is denied or withdrawn, so long as you are not subject to mandatory detention. Okay, so they are going to issue, and you see, in law, when we say, if you've, in law school, you'll be taught, and in several cases, there's a difference between will and may. Where the drafter or the legislative drafter or the drafter of the policy memorandum says that USCIS may issue an NTA or a notice to appear, it means that it's permissive. The officer's discretion is being called here. Like, you may issue, it's not, you don't have to issue. And so you will look at the circumstances, the totality of the case, and decide as an adjudicator whether or not you want to enforce or carry out what you are supposed to carry out. But where the law says, or the memo or policy says, USCIS will issue, it's mandatory. They are going to issue. There's just no room for discretion here. They will issue. Will is certain. There's no may, there's no, well, maybe, or perhaps, or permissive. It's almost a given that they are going to refer you to immigration court if you've been arrested, charged with criminal offenses, if your benefit request is, number one, denied. What does this mean? You have met a US citizen and you've gotten married, and the citizen has applied for a green card for you. And, while you're, before the green card, they apply for the green card for you. Let's say you got arrested for a road traffic offense, something. Maybe you knocked somebody down, or you hit another car and caused bodily injury or something. If you are convicted of the criminal offense, perhaps you were negligent as you were driving, then USCIS will refer you to immigration court to go and answer in court. Now, if your benefit request, you withdraw it, your case will also be referred to immigration court. What is a withdrawal? What is a withdrawal? So if you apply for an immigration benefit, okay, you apply for an immigration benefit. Let's say you apply for a green card, and you decide that for some reason you don't want to pursue the application. You don't want a green card anymore. You're withdrawing. Sometimes it's a good legal strategy to withdraw if you could get in trouble by pursuing your application. Okay, we've had cases where we've advised people to withdraw their applications, where, for example, you get married and it was a fraudulent marriage. You get married, you paid money, and sometimes, they'll come and see us and we see that, oh, USCIS is likely going to conduct or has started conducting investigations into this case. They can go into your wife's mother's house and then show your picture and ask your wife's mother, is your daughter married to this man? And sometimes the wife's mother has no idea that daughter is even married. They'll go to your wife's workplace and find out, okay, can we have the records? Perhaps by subpoena or whatever, can we have the records? They have so many ways of checking databases. And they see that, oh, your wife stated in her employment records that she's single, and yet she's claiming to immigration she's married. So sometimes USCIS will start to put two and two together. And at the time, what you want to do is to try and stop them from going too far investigating, because once they do investigate and they find that, there is fraud by substantial and probative evidence, then you get something called a 204C bar, a marriage fraud bar, and you can never ever get a green card in the United States or any type of immigration benefit. So a withdrawal can be an effective tool to stop them from getting too deep into adjudicating your case. And the legal effect of a withdrawal is that they don't bother their resources anymore. They don't continue to spend time or money sending agents to, or field investigators into your home, into the communities to find out about your marriage or to conduct investigations. You just stop them in their tracks. A withdrawal can be an effective tool in some situations where you apply for citizenship and you're not eligible. And maybe you apply, sometimes people will apply without consulting with a lawyer, and then they get a notice of continuance. And then they come to us and we realize that, oh my God, you do have a deportable issue, an issue that could cause you to be referred to immigration court and be put in deportation proceedings. At that point, applying for US citizenship is not the best for you. So we could advise you, we have to withdraw or file an effective withdrawal. Now, the policy memo is saying that in some situations where you are, you have withdrawn your case, if you are convicted of a criminal offense, then you are likely to be put in removal proceedings. You could be sent to immigration court. Okay, so just be aware. These things are to let you know when your case could be sent to immigration court. Avoid criminal issues. Avoid getting into any type of problem with the law as much as is within your power. Now, let's go to the fourth ground where USCIS is going to issue or send you to immigration court, where there's fraud and misrepresentation. Okay. So it says here in the memo, to uphold the integrity of the immigration system and address fraud, USCIS will issue an NTA in cases presenting substantiated fraud or material misrepresentation. When your case has substantiated fraud or material misrepresentation, they will issue an NTA. Again, it's not permissive. They're going to send you to immigration court where they can substantiate that there's fraud, meaning there's palpable fraud. They can actually touch, they can see the fraud. The fraud is there. They've verified and they have evidence that you've committed fraud some way, somehow in your case, or there's a material misrepresentation. Okay, so fraud, let me explain again. Fraud is where you willfully misrepresent a fact, a material fact, with the intention of seeking an immigration benefit, and you are doing that, it's done with an intention to deceive, and you are doing it to an immigration officer, and you are actually able to procure a benefit out of that fraud you committed, or out of that willful misrepresentation, or lying about something that, lying about something, right? So you lie about something that impacts your ability to get an immigration benefit. And because of the lie, you were able to get the benefits, because without that lie, you wouldn't have gotten that benefit. That's fraud, immigration fraud. Material misrepresentation is presenting something that is not the case. Okay. So for example, a material misrepresentation could be claiming that perhaps you have what can we use as an example? Material misrepresentation. Let's say you have a criminal, you are aware that you have a criminal conviction, and then you will misrepresent and pretend that you don't have any criminal conviction by omission. You can misrepresent by affirmative conduct, and sometimes even by omission. Failing to submit some information could be viewed as a material misrepresentation, because you misrepresented, or you presented facts alternatively. You didn't present the truth, and it was material, meaning it was that lie or misrepresentation could impact the outcome of your immigration case. It could sway it in one way, positively in your favor. Okay, because if it was immaterial, then it doesn't really matter. So for example, if you are married to a US citizen, and let's say you were not properly divorced, and you are aware that you were not properly divorced, and so your current marriage is invalid, and you go and present a fake divorce decree, and you submitted that, oh, my first marriage, I have a divorce decree, when you know that that divorce decree is fake. That's a material misrepresentation, because your new application, where your spouse is supposed to apply for a green card for you, it will not be approved if you don't have a valid and underlying divorce decree from your prior marriage. And it's material because of the impact on the outcome of your case. Okay. So, for example, if you claim that you lie about the fact that your spouse is maybe he's originally from Nigeria, he's become a US citizen, and then you say that, oh, he's Igbo when he's not Igbo. That doesn't really matter. It's not a material misrepresentation, because whether he's Igbo or he is I don't know which other type of tribe in Nigeria, it doesn't change the outcome of the case. Maybe I should use a Ghana example, where you say, oh, your husband is he's from the Ashanti region, and whether he's actually from Cape Coast, it doesn't really matter, because that misrepresentation is not material. It doesn't go to the to whether or not you are eligible for the benefit you are seeking. It's immaterial. So if it's material misrepresentation, then your case will be sent to immigration court. Okay. Now, what they're saying also under this category is that USCIS is going to issue an NTA, a notice to appear, or an immigration court summons, where there's negative action, or they deny your application, or there's any unfavorable determination. If the adjudication or the decision goes against you, there will be an NTA that will be issued. Okay. The NTA will be issued against you, even if your case is denied for any other reason apart from fraud. So if you fail to prosecute your case, what does it mean? You receive an RFE, a request for evidence. You don't submit the evidence and the case is denied. You're going straight to immigration court if you have fraud in your case. Even if the case was not denied based on fraud, you have fraud in your case, you're going to be sent to immigration court. If there's abandonment means that you don't pursue your immigration case to its logical conclusion. So you just leave the application. You receive the notice of intent to deny, for example, and you have 30 days to respond. You don't bother to respond or tell immigration that, oh, here's the answer to what you are asking. Then if the case is denied, you'll be sent to immigration court. If your application is terminated or denied based on the fact that you've withdrawn the case, let's say petitioner goes and says that I'm withdrawing the case, your case could be sent to immigration court so long as there's fraud. Again, even if there's no fraud, we'll be going to that portion of the NTA policy issuance. So don't worry. But here we're talking about where there's fraud on your record. Okay, and then where your approval is revoked. Sometimes USCIS will be this, they will approve your case. They could say, oh, okay, yeah, we've approved your case. And then a few months later, they find derogatory information and they will revoke the approval, meaning they're rescinding or going back on the approval. They're like, okay, we approved this, now we're revoking it. It's no longer approved. In such a case also, then your case can be sent to immigration court so long as you are removable and USCIS determines that there's fraud in your record. Okay, let's move on to the next thing. TPS, we will skip that. Let's go to number 7, special circumstances involving NTA issuance. So it says here in the policy memo, typically USCIS will issue a notice to appear after taking adverse action on your benefit request. So if they take a negative decision or they deny your case, simply put, that's right there, denying an application, they will issue you with an immigration court summons. You will be sent to immigration court. However, USCIS may issue an NTA in other circumstances that don't necessarily result from a denial of your case. In some cases, some people will ask that they can tell immigration and say, look, can you just take me to court? That's where I could probably get relief or get a green card. And that's also a legal strategic decision that you can take. Sometimes if you are not, you may not be eligible for an affirmative application, you can ask USCIS in writing and say that, okay, can you send me to immigration court so that I can try to get a green card through there? And this kind of process, you have to be careful. You don't just ask to be crucified. You don't just tell them, oh, take me to immigration court, because immigration court is not a child's play. It's a very dangerous and slippery place to be. So you want to make sure this is a strategy that you've reviewed with your attorney very well, and um, you know, the outcome will be something that you are likely, to anticipate if you are sent to immigration court. And they will need to make sure that they are able to have the correct information to legally issue you with an NTA. Okay, let's see here. Now, if you look at section 239A, usually in order for them to issue you with an NTA, USCIS needs some information. They'll need the acts or conducts that are alleged to be in violation of law. What have you done? Because they don't just send people to immigration court. You must have done something wrong. Either you are an overstay, you shouldn't be here in the United States. Let's say you came in on a B2 visa or a tourist visa. You've overstayed your I-94. You are here in violation of law. You could be sent to immigration court because of that. Then they'll need the charges against you, then the statutory provisions that you have violated. Then they also need your address as well as your telephone number in order to usually issue you with an NTA. Okay, let's this, yes, still under, I believe, number 7, under number 7B. I'm sorry, number 7C. This is one of the changes in policy. Okay, now let me reiterate. Under President Biden, it wasn't all the denied cases that were being sent to immigration court. It was denied cases where there was some serious issue like fraud or misrepresentation, or somebody was deportable, has committed a serious offense or things like that. But now all these denied cases will be sent to immigration court. If you come here under C, it says USCIS will issue an NTA to a removable alien or non-citizen who is a beneficiary of an employment-based petition where the decision on the petition is unfavorable. So if you apply for or you file an employment-based petition, like you've done an EB2 NIW, let's say you've done a green card based on an EB2 NIW or any type of employment-based petition, right? And the decision is unfavorable. They deny your decision. And number 2, you are not lawfully present or you are otherwise removable. You are out of status. And number 3, you are the signatory of an I-129 form. Okay, you file the I-129 petition. Then they are going to issue a notice to appear. So please make sure that you don't fall out of status. Even if you are pursuing one type of status, make sure that you have a backup status some way, somehow. Talk to your attorney on what to do in these type of situations, because now, even in Trump's first presidency, what people call Trump 1.0, when he became a president in 2017 to 2021, where employment-based petitions were denied, people were not being sent to court. Now, if your employment-based petition is denied, then USCIS will issue you with an NTA if these conditions that I just mentioned are met. Okay, now let's look at D, certain naturalization cases. This is another very interesting part you have to pay attention to. If you apply for naturalization, citizenship, you want to be a US citizen, and they find out that you are deportable under INA section 237. So for example, you are convicted of certain aggravated felonies, or you are convicted of deportable offenses after obtaining your green card, and that makes you ineligible for naturalization, or you were inadmissible at the time of adjustment or the time you were entering the US and you are deportable, then obviously you are not eligible for naturalization and you can be sent to immigration court. Okay, one of the very interesting things we see here, for example, is that some people, they don't qualify for citizenship. They just sit in their bedrooms, because the forms are available for free, online. People just download them and start typing anything and sending them to immigration court. See, when you are typing and putting in information, there's no legal bell in your bedroom that will ring and tell you, oh my God, you have just incriminated yourself. Ding dong, can you stop? There's nothing. And which is why it's a good idea to always have an attorney, because the attorney is the one that will review your eligibility and can be your sounding board and tell you, no, this is a major problem. We're not going to submit this type of case, right? So people will sit in their bedrooms, they will come in on a particular type of visa, immigrant visa, which will tell them, or they're not supposed to do certain things. For example, there are some visa types where you should not get married before you come into the US, like F2B category, F1 category. You cannot get married before being admitted, even if you have an immigrant visa. If you do that before you come into the US, your entire immigrant visa or your status is revoked. If you don't know these things and then you go and apply for citizenship and they find out, then you will be sent to immigration courts because you were not admissible at the time of coming into the US, right? So there's several ways that you can be deportable, committing some offenses, just violating temporary restraining orders and a whole lot of a list of deportable offenses, criminal activities, or things that you shouldn't be involved in. Be aware of these things. If you have these type of things, you apply for citizenship and they find out that you are deportable, you are going to be sent to immigration court, and it becomes very stressful to get out of immigration court. All right. So now enough of the chatter. We're going to, I think we can just let's just mention here. In general, prosecutorial discretion is the authority of an agency charged with enforcing a law to decide whether to enforce a law against someone. The exercise of prosecutorial discretion can mean that USCIS either decides to or not to assess the full scope of its authority as permitted under immigration law. Okay. Yeah. Let's now let me see if I can take some questions and then we can. Oh, I hope you guys could see me when I was sharing the screen. Okay, well, let's see if we have some questions that we can answer. Betty Biney says F1 cannot be married before entering. Yes, you cannot get married before entering. So we have two categories of filings. Okay, we have the immediate relative category. Those are the spouses, minor children of US citizens, and parents of US citizens. Then we have the second category called preference immigrant category. Preference immigrant category, those are the people that you have the F1, which is the unmarried son or daughter of a US citizen. We have the F2A, minor child and spouse of a green card holder. F2B, adult and married son or daughter of a green card holder. F3, married child of a US citizen. F4, sibling of a US citizen. F1, your category in essence means you are unmarried, and so you cannot be married before you enter the US on that immigrant visa. See, immigration law has a lot of loopholes, tricks, and people just fall in trouble sometimes even without meaning to break the law, which is why it's always a good idea to work with an attorney. Even if you didn't work with an attorney, call and find out, okay, let me speak with the attorney. Here's my case. Is there anything? Is there a problem here? That's why we went to law school, to help you on these things. But F1, you cannot be married before entering. Otherwise, you revoke your petition and your green card becomes deficient. It becomes, a problem. And usually you will not be able to become a US citizen if they catch that issue. Okay, so let's see if we can find some TikTok. Grace Light Hub on TikTok says immigration is costly, oh, almost $5,000 in everything. Hey, well, guys, it is what it is. See, immigration is very costly, absolutely, because sometimes, I mean, the stakes are very high. The stakes are very, very high. And you see, if you look at it, it's like, oh, 5,000. You see, one interesting thing I tell sometimes my clients and my team members is that immigrants are they can be a very interesting group of people. Somebody will tell you, oh, pay me $25,000 and I will give you, I'll get married to you and I'll give you a green card. That's a fake process right there, right? But people will pay. People will find $25,000 for the fake process. The same immigrant, you'll come to a lawyer and the lawyer will tell you, oh, there's this legal route, it costs $5,000. The immigrants will suddenly start crying and say that I don't have money, but they'll find $25,000 or $20,000 and go and give it to somebody for a fake marriage. And after they do that, the people will run away. And unfortunately, you cannot enforce an invalid contract, right? So the process is not lawful, they find the money. When it's a lawful process, 5,000 is suddenly a lot of money. Remember also that the immigration process takes a very long time, sometimes 2 years, 3 years. If you split that 5,000 in 3 years, think about what the law firm is even making. Sometimes what, $200 a month. It's very, very stressful. And the law firm is on the hook for putting everything together, tracking your case, advising you, helping you, that legal expertise. So it's not that much, because think about it, even if it's $200 a month, a year is what, 2,400. 2 years is almost the $5,000. That's right down the drain, so um okay, Grace Lighthouse says, and this is even charitable organization. The lawyers don't make anything. Okay. Okay. All right. Sweet on TikTok says, B2 expired, married now and applying for adjustment of status. How should I be worried? Okay, that's a good question. Now, the case has always been that if you are the spouse of a US citizen and you came in, inspected and admitted under section INA 245A, then you have an I-94, so you should be good to go. You're married to a US citizen, even if you overstayed your I-94 for 30 years, 100 years, 200 years, that overstay will usually be forgiven by immigration. You will be able to apply for a green card through the adjustment of status process, and you can get your green card and move on. The only problem is this recent policy memo. Now, if your case is denied and you are out of status, you are going to be sent to immigration court. You see, and I was telling one of my consults today, if you are married to a US citizen and you are sent to immigration court, it's a genuine marriage, you don't have too much to be worried about, because ultimately you can still apply for adjustment of status in court, in immigration court, and you will get your green card and become a US citizen. The only problem with being sent to immigration court is the stress and the money you are going to waste. In that type of situation where you are married to a US citizen, you have a genuine marriage, you're eligible. If your case is denied, you are sent to immigration court, the end game, you are likely to get a green card. But by the time you get to that end of the road, you would have really sweated. You would have lost a lot of money, because it's very stressful, it's expensive, and your peace of mind. You see, so it's not a good time to DIY, do it yourself, because if your case gets denied, then the latest policy memo that was issued on February 28th, just a week ago, mandates USCIS to send you to immigration court. So it's a good time to work with an attorney to make sure, because as I tell my clients all the time, we file hundreds of these applications all the time. And so we know what they're looking for. We have a method to their madness, right? Because if you do it all over and over and over again, you know what they're looking out for and you are able to meet their requirements. So yeah, I mean, if everything goes well, you should be fine. But if anything goes wrong, then immigration court will be your new home. And if you think that is worth hiring an attorney for, I would absolutely do that. Okay, great. I see some people following us on social media. Please make sure you follow us on social media, AK Pukulo, across all social media platforms. Like this live video. Keep dropping your comments. If I'm communicating to you, if you understand what I'm saying, just drop me an emoji to show me this, that you guys can hear me, you understand what's going on, and that can ginger us to do more. Okay. All right. So let's see if we have some other question. Let's see here. We're going to be ending this live video soon. Let's see. Some of the questions, I don't understand them, so I'm just having to skip them. Let's see here on Instagram. Okay. Tony B Live says on Instagram, please, what about O2 visa? Can you get married after you have overstayed your visa? Also, if you are married to a US citizen, does age gap really matter? Let's say 20 years difference. Yes, so long as you're inspected and admitted, you can adjust your status. If you are married, even if you've overstayed, once you are married to a US citizen, then your overstay will generally be forgiven. Does the age gap really matter? That's a good question. Yes, age gap matters. I mean, you see, when you apply for a US immigration benefit, the burden is on you, the benefits requester, to show that you're eligible for the benefit. And one of the things they're looking out for in a marriage-based application is that the marriage, you entered into the marriage to establish life together. And one of the, I'm sorry. Okay. One of the things that they look out for, one of the fraud triggers. Okay, we're back on Instagram. One of the fraud triggers is the age gap. They look at the age gap. If there's a very wide age gap, then it's a fraud trigger. But obviously, that's not looked at in isolation or in a vacuum. It's looked at the totality of the circumstances, your entire case together. It's a holistic view of your case. And so, age, 20 years, it matters, but what are the other types of evidences that you have? Do you have evidence that you guys are truly in a relationship, in a bona fide marriage? How did you meet? How did the relationship evolve? Because let's be real, there are people who have sugar daddies, they get married to them, or there's a big age gap. So that's certainly a possibility. The fact that there's a 20-year age difference or a 30-year difference or even a 40-year difference does not mean the marriage is not real, but it depends on your other evidences. Okay. Okay, let's see if there's another question. Let me see if there's something here. Okay, so Kabuna Baka says, how long does the I-485 take to be approved after the I-130 approval? It just depends. It depends. It really, really depends. We've seen cases where the I-130 would be approved, and then the next day the 485 is approved after the interview. Other cases, I-130 can be approved, and then they'll contact you for an interview for the 485 because they want to establish the admissibility of the foreign national, right? Let me explain that the I-130 is the petition of your US citizen spouse if you're married, or your green card holder spouse. The I-485 is the petition of the foreign national, so the immigrant who's applying for the green card. It's their petition. So sometimes they find that the relationship is fine, so they'll approve the case, the I-130. But the 485, they want to determine that you are admissible, you don't have any issues that make you inadmissible or whatever. So sometimes that could take a while, and there's just no rhyme or reason. Like, the timeline really, really differs. It just depends. Okay. All right. All right. Thank you guys so much for joining us. Please like our page. Um, like our page, follow our page. Okay, so there's somebody says one B says final hearing for asylum is 2027. Please, am I safe from ICE? Am I safe from ICE? Okay, so only US citizens are safe from ICE, okay? Only US citizens are safe from ICE. Even then, they are not totally safe from ICE because they could be, wrongly profiled as non-US citizens. So only US citizens are safe from ICE. Obviously, practically speaking, if you have lawful status, you're a student, you're a green card holder, you're also safe. You're generally safe. Final hearing asylum 2027, meaning you are out of status. If you haven't committed any crime, you are living your life very carefully, going about your duties. I don't think you are a target of enforcement at all. They are not really going to come after you. Just make sure that you understand what your rights are. Don't just go open your door anyhow when you hear a knock. Some of the people, some people have called our law firm. They thought, oh, it was my wife, opening the door. They just heard a knock. They just opened the door and ICE grabbed them. Like, okay, yeah, we're looking for you. So you have to understand what your rights are, what you need to do. You carry yourself with, you have to be very careful, even though you are not a target. If you are going about your merry way and some way, somehow you happen to fall into their hands, then you will not be safe from ICE so long as you are undocumented. You may have a hearing pending, and we've heard about cases where people have asylum cases pending, no criminal issues, and ICE has apprehended them. It's not the norm, and honestly, it's not the norm, but it's happening. So just you don't necessarily have total safety, but obviously you're not a target, so just be careful. Just be careful. That's what I will say. Um, okay. Sweet says, what are some of the things that can deny a case? That's a very interesting question from TikTok. One of the main things we've seen is something called the affidavit of support. The affidavit of support is the form that the petitioning sponsor has to file with the government to show that they are entering into a contract. I'm sorry. They're entering into a contract with the US government. They're going to be financially responsible for the beneficiary, and they'll take care of him. He's not going to become a burden on the US taxpayer. The beneficiary is not going to be taking Medicaid, food stamps, benefits, and all these things. The US citizen will take care of that foreign national. So, as part of that contract, the US citizen or the green card holder, they have to submit their most recent tax returns, their W-2s, 1099s, pay stubs, evidence that they are making money 125% above the federal poverty guideline for their household size. If the petitioning sponsor is in active military service, then it's 100% above the household size. HHS, Home Health Services, they always release the poverty guidelines, and it's for means tested public benefits. They have a poverty guideline threshold for household each year to determine who is eligible for Medicaid or food stamps or some of these public benefits. So they just released the 2025 poverty guidelines on March 1st. Now, if your spouse, who's a foreign national, goes to take, let's say, Medicaid or food stamps, then your petitioning sponsor, US citizen, has to reimburse the government back that money. It has to reimburse the government, is what I should say. That your spouse will reimburse the government. So one of the things is that the affidavit of support form it can get a little complex if you don't calculate household size well, if you don't demonstrate that you are making enough money. If you don't make enough money, you have to sometimes use a joint sponsor or a household wage member. If their income is not enough, if there are issues with the affidavit of support, and I see it all the time, people's cases gets denied because of the affidavit of support, and they could be sent to immigration court for that. Sometimes basic lack of documents, certain things that you should have submitted, you didn't submit. One of the things I tell people is that the immigration officer, they have hundreds of thousands of applications they're reviewing. How do they know that your marriage is real? They really don't know. They're just going to be reviewing applications, and they're kind of going to be looking at whether you've box checked certain things. So that's why you have to know what you are doing and how you are doing it to ensure that your case is not just denied because people will call and be crying, oh, our relationship is real. Why did our case get denied? It's not just about, printing out a bunch of pictures, filling out forms and sending it. There's a legal standard, there's a burden of proof. You have to meet that legal standard. You have to know who the burden of proof is on for the type of case that you're submitting. You have to understand these things. Some people will file and then their case gets approved by chance, but it's by chance because they sometimes don't even understand what the standard of proof is for. In a marriage-based case, it's by preponderance of the evidence, and there are different standards in law. We have, beyond every reasonable doubt. We have substantial and probative evidence. We have clear and convincing evidence. We have preponderance of the evidence. We have, different standards, and depending on the type of case you're filing, then you will have a particular standard that will be used in your case. So those are some of the things that they look out for. Is there a bona fide marriage? Do you have any criminal records? Have you filled out the application properly? um TikTok doing its thing again. Do you have the correct birth certificate? Have you included the social security number of your spouse? There's just so many things that could cause a denial of your case. So there you have it. I hope that answered your question. All right. Thank you guys for joining. And um, don't forget to follow our page, share our live feed, share the video, at least drop a comment. If you've benefited from this, please drop us a comment before you leave. Any emoji, thumbs up, high five, whatever emoji you can, drop us an emoji. And we'll wrap up with you today. I will see you guys hopefully again sometime this month, hopefully next week. We're going to be trying to come weekly this year. Last week we couldn't make it, but hopefully we'll be coming more and more this year as we try to help you guys through this tough period that we're in. If you do need our help, obviously you know how to get in touch with us, but let me share our contact number 802-780-0564. If you're outside, we're on WhatsApp. Internationally, you can find us on WhatsApp and you can get in touch with us. You can also just Google AK Poku Law on Google and you'll know how to get in touch with us. Email us, call us, text us, and we'll be here to assist you as always. Thank you all for joining, and I'll see you guys soon. Take care. Bye. Bye-bye. Thank you.